located in the hallways behind the hearing rooms. Chair now moves to correct the minutes for the meeting held on April 4th and March 21st. Is that right? Is there objection? Chair hears none, and the motion prevails. If there's no further business, and I'm sorry. That was just correct. Okay. Chair now lays out House Bill 1138 and recognizes Representative Martinez to explain the bill.
Good morning, Mr. Chairman. I believe there's a committee substitute.
Chairman Canales offers a committee substitute. Is there objection? Chair hears none. Chair recognizes Representative Martinez.
Thank you, Mr. Chairman. Members, a committee substitute for House Bill 1138 will add counties with a population of 500,000 or more and leave the current statute for municipalities having a population of 100,000 or more. Every year, individuals who fire a firearm into the air without an intended target claims lives and causes severe injury. Many of you all know I was a victim of celebratory gunfire in 2017, and in the United States, these occurrences of reckless discharge are most likely to occur on New Year's Eve, the 4th of July, in the form of celebratory gunfire. This bill amends Section 42.12 of the Penal Code to include reckless in front of discharge of a firearm. This bill seeks to address the issue of reckless discharge by expanding the applicability of the current statute to include counties with a population of 500,000 or more.
Let the record reflect that Chairman Canales is present. Please proceed.
Thank you. However, no changes are being made to the penalties in the current statute. It also adds that it does not affect county or municipality law and does not require to enact an order or ordinance that prohibits the discharge of a firearm. At this time, I'll entertain any questions, Mr. Chairman.
Members, any questions? Okay, we'll call you back up in just a moment. Chair now calls Richard Hayes. We have you registered as Richard Hayes, representing yourself against the measure.
That's correct.
Is that correct? Okay.
Yes.
Please proceed.
Honorable Chairman, members, this bill essentially, give you a little bit of my background. I'm a criminal defense attorney. I handle almost exclusively firearms related issues, self-defense related issues. The way that we see the current law weaponized, and I kind of use that term, is pretty much anything that doesn't fall inside of kind of ordinary categories of self-defense. Think about defense against animals. Think about warning shots. You know, sometimes warning shots, even though I don't encourage any of my clients to do a warning shot, things that don't kind of fit neatly into our current laws are criminalized under the reckless discharge statute. For the most part, it doesn't affect too many people, you know, because current law prohibits it in big cities. But what I do see is, because right now it applies to municipalities with a population over 100,000, what I do see, though, is right now it is used against landowners. For example, let's say you set up a range on your property. We see land developers come in, develop property, want to shut down the family range or sports shooting range even, and we see it kind of weaponized against those folks. So I just think by expanding this law, we're going to be infringing on those folks' ability to engage in sports shooting. That's all I have.
Members, any questions? Yes, Representative Goodwin.
So the example you gave was that someone might own a piece of property, had vacant land next to them, someone else comes in, and now it's really not safe for them to shoot their gun on their property because of someone moving in next door, which that I don't know. I'm having a hard time with that argument.
So I'll give you a specific example. We had a sports shooting range, and generally sports shooting ranges have lots of protections under different parts of our law. But we had no evidence that bullets were leaving the property, but we saw developers putting pressure on local police departments. They weren't even coming out and investigating this stuff. They were just writing Class C tickets every time they heard a gun go off. And so while we all hope that...
Who were they giving those tickets to?
To the owners and the operators of that range. And even when they weren't even present on the property or even possessing firearms. So we do see this kind of used, to lack of a better term, recklessly against sports shooting ranges and people on their own property. I've seen lack of investigations going on. It doesn't take a lot to make an allegation that a person recklessly discharged a firearm, and so I think this would just encroach on that.
I think his intent is like when people shoot off a gun on January 1st or what have you. So
Sure.
I'm, again, having a hard time. seeing your argument, but thank you.
Any other questions?
I do, Mr. Chairman.
Yes, Chairman Harless.
It seems to me like that's an education issue for law enforcement on what not to do and what to do. When you have a gentleman like my friend over here who is victimized by a reckless discharge of a firearm, for me, it's problematic for anybody to get up there and testify against this bill. And to me, that's an education of law enforcement, why anybody would write a ticket if it's something that's permitted within the boundaries of that specific property. But with his intent of his legislation is to stop accidental or purpose discharge of weapons for celebratory reasons. It's hard for me to even understand how anybody could object to that. So thank
Well,
you for being here.
Yes, but I mean, if somebody is struck by a bullet, I mean, that would be aggravated assault. If you recklessly cause serious bodily injury to another person, that would be aggravated assault.
Well, unfortunately, there's some people that don't understand common sense, and you have to put things into laws for them like this to prevent accidents from happening like happened to our friend over here. But thank you for being here.
Yes, sir.
Members, any other questions? Thank you, sir.
Thank you.
The chair now calls Rick Reinhardt. We have you registered as Rick Reinhardt, representing yourself, testifying against the bill. Is that correct?
Yes, that's true.
Please proceed.
Okay, I am a gun owner. I have a property that I can shoot on, and the word reckless bothers me because as a gun owner, we have seen governmental agencies move the goalposts one way or another, like the ATF does on many occasions. This reckless, if I'm on my property and I'm shooting at my target and that's it, who's to say that I'm being reckless? I would like reckless to be. I understand shooting in the air, but it doesn't say that. So for that reason, I am against this bill.
Members, any questions? Thank you.
Yep.
Chair now calls Teresa Beal. We have you registered as Teresa Beal, representing yourself in favor of the bill. Is that correct?
That is correct.
Please proceed.
Just generally speaking and quickly speaking, as a pharmacist, I am liable for losing my license if I recklessly dispense medications without any prior authorization checks, MTM, drug interaction checks whatsoever. It seems that that kind of logic should be transferred to anybody who owns it and discharges it in a firearm inappropriately. They should be liable to some kind of prosecution or concerns about any legal matters involved with discharging those firearms accordingly. Again, just speaking from a pharmacist perspective, I can lose my license if I do something reckless. Others should be held accountable in other areas such as gun safety. Thank you.
Any questions, members? Thank you, ma'am. Chair now calls Michael Belsick. We have you registered as Michael Belsick, representing yourself, testifying against the bill. Is that correct?
That is correct.
Please proceed.
For the situation originally stated of
Let the
firing
record
up in the
reflect
air,
that Chairman Burrows is present.
sorry. For the example stated here of firing up in the air, I totally agree that is reckless, has no purpose, and someone could get hurt. Is hunting on your land reckless? Is, like the last person said, if I have a gun range on my large acre ranch and I'm shooting into a backstop, is that reckless? What worries me about the bill is that there's no definition of what is reckless. You didn't define shooting up in the air. You didn't say shooting in the general direction that other people are. It is totally subjective for someone that would say, oh, that was reckless. And now you're on the defensive of trying to defend yourself. So that is why I'm against the bill, just because it did not definitively state what reckless was. Thank you. Any questions?
Members, any questions? Thank you, sir. Is there anyone else wishing to testify on, for, or against the committee substitute to House Bill 1138? There being none, Chair recognizes Representative Martinez to close.
Thank you, Mr. Chairman and members, and just keep in mind that this is only including counties. This bill is already in statute, or this law is already in statute, and I request your favorable consideration.
Members, any questions?
And I close.
Thank you.
Representative Holland.
Vice Chair Martinez, I
Yes, sir.
think we all understand the spirit of what you're trying to do in this bill. Reckless discharge of a firearm for celebratory purposes. Is that
Correct.
correct?
Absolutely.
I think that we could work on this to figure out a way to clarify the language to where it's expressly stated that you're not allowed to shoot a gun in the air for celebratory purposes. We're not trying to go after people's gun ranges
Right.
or their hunting or their personal enjoyment of their property when they're shooting firearms on their land, as long as they're able to do so. Would you agree with that?
Absolutely. I agree with you 100%.
I like the spirit of your bill, but I also understand people's concerns about maybe infringing upon other things that they like to do for enjoyment, so maybe we can work on that a little bit.
Absolutely. I'm a hunter. I have plenty of weapons myself, so I understand the importance of it. But at the same token, we want to make sure that people can celebrate freely, happily, and enjoy their holidays.
Let the
with their
record
family.
reflect that Representative Troxclair is present. Chairman Canales.
I just want to add, because I was part of your story in the sense that the night that it happened to you, we were going to set off fireworks. And I told my wife we were going to wait till after midnight, which she wasn't happy about. And she said, why? And I said, because of the amount of celebratory gunfire. And that night you could count hundreds and hundreds of guns going off. In the morning you were on the front page. And so I remember it clearly. And where we live, this is something normal, and it's unacceptable.
Thank you, Mr. Chairman.
Members, any other questions? Representative Bowers.
Thank you, Mr. Chairman, and thank you, Representative Martinez. I think for clarification, the definition of reckless certainly would not include just someone who definitely has a range, they're shooting at a target. You know, the definition is of a person or their actions without thinking or caring about the consequences
Correct.
of an action. So I believe that what you're doing is exactly right, and we're thankful that you're part of the legislature and that
Thank you.
survived.
Appreciate that.
Any other questions, members? All right, thank you.
Thank you, Mr. Chairman.
Yep. The committee substitute to House Bill 1138 is withdrawn. At this time, House Bill 1138 will be left pending. Chair now lays out Senate Bill 599 and recognizes Representative Anderson to explain the bill.
Yes, he's there.
Thank you, Mr. Chairman, members. It's a pleasure for me to be here today to lay this bill out for you all, Senate Bill 599. This bill was brought to you by my district clerk, and basically Texas county and district clerks are more often housed in courthouse facilities where other elected judicial officers have judicial CHL and LTCs, allowing the judges and prosecutors to carry to their respective offices for self-defense. Oftentimes, clerks are required to work outside of the normal office hours when courthouse security has left for the day, while others are housed outside the courthouse with no security at all. Clerks have the constitutional duty to collect fees, fines, and other court-ordered monies and deliver them to the treasurer, often in another county facility. Additionally, instruments of the court are filed in the office of the district clerk, such as restraining orders, writs of garnishment, and tax suits that can lead to loss of property. Adding district and county clerks to the judicial CHL LTC officers would give those who wish to carry the opportunity to do so. The committee substitute adds county clerks to those already allowed to carry per their request. And with that, members, I'd be willing to answer any questions, and I believe we have a resource witness.
Members, any questions? We'll call you back up in just a moment.
Thank you.
Chair now calls John Gimbel. John Gimbel. Okay, we have you registered as John Gimbel, representing yourself, and as your as the elected district clerk of McClellan County, in favor of the bill. Is that correct?
Yes, sir.
Please proceed.
Well, good morning. Thank y'all for seeing me. I just got in from Waco. It was a little bit of a drive, but we're asking for this just to have the same right to defend ourselves as the district attorneys and judges do, so that we can enter and exit the buildings at courthouses and be able to protect ourselves coming into and out of the buildings after hours and before hours. It doesn't affect a judge's ability to control their chambers or their courtroom, just the same way that the district attorneys carry to their offices and back.
Members, any questions? Thank you, sir.
Thank you, sir.
Chair now calls Michael Belsick. We have you registered as Michael Belsick, representing yourself, in favor of the bill. Is that correct?
That is correct.
Please proceed.
I'm for the bill. Oh, sorry. I'm for the bill. It's similar to HB 1648, if I recall correctly. And I think in today's day and age, it's a very prudent thing to have. As already mentioned, there are certain people that are allowed to carry, and I just think adding this is just a wise idea. Thank you.
Any questions, members? Thank you, sir. Chair now calls Jason Hester. We have you registered as Jason Hester, representing the Texas Department of Public Safety, testifying on the bill as a resource witness. Is that correct?
Yes, sir, Mr. Chairman, that is correct.
Members, any questions of the resource witness? Yes, Representative Goodwin.
Thank you. So does this restrict it, or is it open to the entire state, district clerk anywhere in the state?
It would be open to the entire state.
Okay, and so currently in a court setting, in the setting that these district clerks are in, who all is currently allowed to carry a gun?
And currently, it would be the district attorney, assistant criminal district attorney, the county attorney, the assistant county attorney. So this would allow the district clerks that are behind that secure area of the courthouse to be able to carry with an LTC, similar to the other court officials that are listed in the statute.
So I guess I'm curious, is there an issue, have there been problems with the safety for district clerks that you're aware of?
I am not personally aware of any, Representative Goodwin.
All right, thank you.
Yes, ma'am.
Members, any other questions? Thank you, sir.
Thank you.
Is there anyone else wishing to testify on, for, or against Senate Bill 599? There being none, Chair recognizes Representative Anderson to close.
Thank you, Mr. Chairman. Reverend Goodwin, I appreciate that question, and this would help those individuals, if they so desire to, when they're outside the courthouse or making these transfers of funds, and the county clerks also asked to be considered to be allowed to carry also. So, members, with any other questions?
Members, questions? Yeah, Representative Goodwin.
Okay, so you just said because of transfer of funds, so they're carrying funds from the court to somewhere?
Yes. They're charged with collecting fees and fines, court-ordered monies delivered to the treasurer, often another part of the county or county facility. And additionally, instruments of court are filed at the clerk's office, such as restraining orders and writs of garnishment and tax suits. And so they oftentimes deal with those things that can have emotional attachment, and that's why they were requesting to be able to carry.
Okay, so that's the primary reason, is that they're concerned for their safety when they're transferring money?
Yes, ma'am.
All right, thank you.
Members, any questions? All right, thank you.
Thank you. I close. I would ask for your
yes.
favorable consideration. Oh, yes, ma'am.
Representative Bowers.
Representative Anderson, thank you, and Mr. Chairman, thank you. I guess in addition to what Representative Goodwin was asking you about the transfer of funds, I'm thinking about odd hours. Is that any reason why this would be necessary? odd
yes,
hours that they would be leaving or coming or going?
Yes, off times that they are not within the regular hours of the court, that they will be traveling. If for specific reasons, we can get John Gimbel back up here if you'd like. He is the district court.
I think maybe that might be good. I think the other question would be rural areas too. You know, would that be any reason?
Absolutely.
Okay. I don't think we need the resource witness, so.
We already had the resource.
Yeah, but he was saying we could bring him back up, so we don't need to.
Thank you. Thank you, Representative Bowers.
Thank you.
Thank you, sir.
Members, without a close, and ask for your favorable consideration. Thank you.
At this time, Senate Bill 599 is left pending. Chair now lays out House Bill 1007, recognizes Representative Turner to explain the measure. Representative Bowers offers up a committee substitute. Are there objections? Chair hears none. Chair recognizes Representative Turner to explain the committee substitute.
Thank you, Mr. Chairman and members. Good morning. House Bill 1007 is the first bill I filed to have this legislative session because, like many of the most important bills we work on, it's one that was inspired by unfortunately, a tragic story from one of my constituents. 2 years ago, my constituent, Don Moore, and his family suffered every family's worst nightmare, something no one should ever have to experience. The Moore family had entrusted the care of their adult son, Joshua Moore, to a caregiver in a group home. Joshua Moore had suffered from severe autism, and the Moore family knew that their son's autism caused behavior problems and frequent outbursts. And they believed that a group home was the best place for him. They believed a group home was where Joshua would be safe and where he would receive the care he needed. Now, his behavior problems were no secret as a result of his autism. The Moore family was aware, the provider was aware, and the caregiver was aware. And because of that, Joshua had a thorough behavior plan that specified he should not have access to anything sharp. And also, they identified certain words that should be avoided as they were known to trigger an outburst. Unfortunately, in July of 2021, Joshua Moore did become upset, and his behavior plan in the group home was not adhered to. In his agitated state, Joshua found a knife that was left in the kitchen sink. In response to Joshua wielding the knife, Joshua's caregiver in the group home pulled a gun out of a nearby drawer and fatally shot and killed Joshua. Now, over the past year, I've gotten to know the Moore family, and they've never stopped fighting for answers about what happened to their son, for accountability for those involved, and the necessary changes in our state's laws to see that this tragedy is not repeated. And as I've worked on this case, I've learned how challenging it is to define these facilities that treat individuals and how best to deal with them. So just to recognize this is not the Human Services Committee, just to give you a brief summary of what group homes are. They're not defined in statute, but in working with the Health and Human Services Commission, we've identified group homes as a community-based residential facility operating under the 1915C Medicaid waiver that provides care to no more than 4 people with intellectual or developmental disabilities. Now, other facilities that are included in this bill, in this committee substitute, are intermediate care facilities, state-supported living centers, and day activity and health services facilities. I think it's important to understand what these facilities are because they're all funded by tax dollars. These are all Medicaid-funded facilities, and therefore I think the state has a legitimate role to ensure safety in these facilities. We named this bill Joshua's Act in honor of Joshua's life, in honor of the steadfast dedication the Moore family has shown to advocating for this change to save the lives of other individuals with IDD. Bottom line, guns have no place in these types of facilities. We currently do not allow guns in hospitals, in nursing homes, in mental health hospitals, because they care for vulnerable populations. Group homes and similar facilities should be provided the same level of protection. Had there not been a gun in Joshua's group home in July of 2021, confrontation never would have escalated to the point that it did, and Joshua would still be alive today. And this is important, I would add, for not only the residents, but also the employees of group homes too. Frankly, the gun that was in Joshua's home was unsecured in a kitchen drawer, could have been accessed by anyone, including a resident, and obviously that could have resulted in even a greater tragedy. So this bill in the committee substitute would simply prohibit firearms in facilities that care for vulnerable populations. These facilities and their caregivers are trusted with the safety and well-being of IDD individuals, but the lack of restrictions on firearms leaves both those living and working in these facilities in danger. Joshua Moore should still be here today. We have a member of his family who is here to speak to you about this case, and I think we owe it to him, to his family, to enact this common sense legislation. I respectfully request the right to close, but I'd be happy to answer any questions.
Members, any questions? All right, we'll have you back up in a little bit.
Thank you, Chairman.
Thank you. Chair calls Lori Haas. Lori Haas. We have Lori Haas registered, representing herself, testifying for the bill, but we're switching her to did not testify. Chair now calls Stephanie DeRoy. We have you registered as Stephanie DeRoy, representing yourself in favor of the bill. Is that correct?
Yes, it is.
Please proceed.
Good morning, Chairman and committee members. I'm here for HB 1007. My baby brother, Joshua Moore, was a person. He had the same wants, desires, and goals like anyone else. Joshua was autistic, cognitively impaired, and IDD. He was also a fabulous uncle, brother, son, and a great friend to so many. He was very special, social in the life of the party. He overcame many challenges he faced, and our goal was always for Joshua to be all that he could be. He wanted independence, a job, and a life as he grew older, just like anyone else. Transitioning Joshua to the group home was a resource and the next step for him to gain independence, as he so desired. It never crossed our minds that the decision of switching Joshua to a group home would ultimately lead us to his death. Group homes are created to have resources and special environments for people with special needs, just as hospitals and other care facilities. Firearms are not allowed there by law. Why was a gun in this special needs home? It would be common sense not to have weapons in mental health facilities that host special needs, IDD, autistic. Group homes shouldn't be any different. Unfortunately, this is only currently the health code, not penal. The caretaker is currently still allowed to continue working with other disabled individuals after bringing a gun into the home and ultimately taking my brother's life. If Joshua's tragedy can help even one special needs person from their death, then his death will not be in vain. There are so many others just like Joshua that need the protection of HB 1007. These individuals are the most vulnerable in our society, and House Bill 1007 can help prevent these such tragedies. No one has to be born with a disability, and no disability should ever cost someone their lives. How many more must pay the ultimate price before we close these loopholes?
Members, any questions? Thank you, ma'am.
Thank you.
Chair calls Michael Belsick. We have you registered as Michael Belsick, representing yourself, testifying against the bill. Is that correct?
That is correct.
Please proceed.
It is possible to have great sympathy for the example that we've just heard. I'm for that. But I also believe that firearms can also be there to save lives. For example, a school grounds. I would like to have resource officers armed for that one case where someone might come in with evil intent to shoot people, shoot kids. So in that case, a gun, while I've not really thought of it being necessary in a school, is necessary. In a similar manner, I think a home like this might also warrant having a firearm for safety precautions. Now, in this particular case, it not being locked away, that's all wrong, and I agree that that's bad. But in the general sense of things, I'm in favor of firearms being there to save lives. And if have to be, take a life if it saves more lives. Thank you.
Members, any questions? Thank you, sir. Chair now calls C.J. Grisham. C.J. Grisham. We had C.J. Grisham shown representing himself and Open Carry, Texas, testifying against the bill, but we're switching him to did not testify. Is there anyone else wishing to testify on, for, or against the committee substitute to House Bill 1007? There being none, Chair recognizes Representative Turner to close.
Thank you, Mr. Chairman. Members, I view this as just a very simple bill that closes a loophole. We don't allow guns in hospitals, in nursing homes, and mental health care facilities. We should extend that same provision to these facilities that care for IDD individuals. There's no questions. I close and expect your favorable consideration.
All right, thank you.
Thank you.
Committee substitute to House Bill 1007 is withdrawn, and at this time, House Bill 1007 is left pending. Chair now lays out House Bill 2291, recognizes Representative Slauson to explain the bill.
Thank you, Mr. Chairman and members. Appreciate the opportunity to lay out 2291 before you this morning. This was a bill brought to us by one of our judges in Hamilton County who raised concerns about the personal safety of judges after their retirement. Under the current statute, there are various places throughout the state where individuals are not allowed to carry a firearm. However, under Penal Code 46.15, there's a list of occupations for which this statute doesn't apply, which includes active and retired peace officers, corrections officers, parole officers, and active judicial officers who hold a license to carry a handgun. This bill seeks to amend Section 46.15 to add retired judicial officers to the list of exempted occupations when that retired judge or justice holds a license to carry a handgun. Peace officers are extended that right to carry a firearm into retirement because they may have an enhanced risk to their safety just from the suspects and encounters that they have interacted with during their career. And the same can be true for our retired judges and justices and judicial officers after they retire from the courtroom. I have two of our judges here this morning from Hamilton County. I believe one is registered to testify before you. I would welcome any questions that you may have and reserve the right to close, please.
Representative Holland.
Thank you, Chairman. Representative Slauson, can you explain how this applies? Because if you recall last session, we passed a permitless carry bill. So why would this even be necessary if a law-abiding citizen's not required to have a permit?
Well, this would apply to other locations, though, that you and I may not be able to carry under
Gotcha. So it's you still have to follow you still have to follow the places you're allowed to take it in and out of because of 30.6 and 30.7 there. Thank you for clarifying that very much. Thank you.
Any other questions, members? All right, we'll get you back up in a little bit.
Thank you.
Chair now calls Lori Haas. Lori Haas. We have Lori Haas registered representing herself to testify against the bill, but we're switching her to did not testify. Chair now calls Michael Belsick. We have you registered as Michael Belsick, representing yourself in favor of the bill. Is that correct?
That is correct, and I won't take much time because I agree with what other people have said before me. So, thank you.
Members, any questions? Thank you, sir. Chair now calls James Lively. We have you registered as James Lively, representing yourself in favor of the bill. Is that correct?
That's correct.
Please proceed.
So, good morning, and I'm a judge in Hamilton County, and I've been a judge for 20 years. In the course of me being a judge, I've issued hundreds of felony warrants in that 20 years for everything from credit card fraud to ag assault and murder. And several years ago, I'd issued a warrant for a member of the Aryan Brotherhood. And the case did eventually come to trial in Hamilton County. Shortly after that, there was another investigation in an adjacent county, and notes were found in that county. It was in Brown County. Notes were found that included my name, my wife's name, the address at our house, various notations about certain times of our schedule. On another occasion, I actually walked out of the courthouse, and as Mr. Holland questioned the location, as a retired judge, if I'd been in the courthouse, I wouldn't be able to carry my sidearm. Because I was a judge and I was able to carry that day, I walked out and I was approached by a woman, and she stepped up to me and she said, "You're Judge Lively?" And I said, "Yes, ma'am." And she said, "Well, you don't know me," but she said, "You issued a felony warrant for my arrest." And she said, "I was stopped in my car by the side of the road. I was taken out of the car. I was arrested in front of my children." And I said, "Well, ma'am," I said, "I can assure you it was nothing personal because I don't know who you are." And she said, "Well, I just wanted to confront you face to face and let you know that I didn't appreciate that." And at that particular time, the fact that I was able to protect myself gave me a lot of peace of mind. In rural counties particularly, we don't have a saturation of security. We walk in and out of our courthouse all the time. I'm in and out of the courthouse constantly. And as I retire, I actually serve on 4 different boards that require me to go to places that I would not be able to carry a handgun if I couldn't exercise the privilege as a retired judge. So that's
Members?
all I have to say.
Any questions?
Any questions?
Vice Chair Johnson.
Okay, thank you.
You said you were able.
Oh, I'm sorry.
One moment.
You said you were able to protect yourself from that young lady. Seems like she had to drop on you, from what I heard. And she just walked right up to you. You were unassuming. So how did your gun protect you from her?
Would you repeat the last part of that question?
How did your gun protect you from the lady?
At that point, it didn't, but it was an option in case I needed it. I certainly felt more at ease because I certainly could protect myself. She had her hands in her pockets the whole time, and I didn't know if she had a weapon or not.
Thank you.
Members, any questions? Thank you, sir. Chair now calls Wesley Verdell. We have you registered as Wesley Verdell, representing the Gun Owners of America in favor of the bill. Is that correct?
That is correct, sir.
Please proceed.
So I'm representing Gun Owners of America. My name is Wes Verdell, and we represent about a little over 2 million people across the United States, and many of those reside in Texas. First, I'll say thank you, Representative Slauson, for filing this bill. And to keep it short, since everything's been said already, we're just going to leave it at that we support it.
Members, any questions? Thank you, sir.
Thank you. Appreciate
Chair
it.
now calls Jason Hester. We have you registered as Jason Hester, representing the Texas Department of Public Safety, testifying on the bill as a resource witness. Is that correct?
Yes, sir, that is correct.
Members, any questions of the resource witness? All right. Thank you, sir.
Thank you.
Is there anyone else wishing to testify on, for, or against House Bill 2291? There being none, Chair recognizes Representative Slauson to close.
Thank you so much. Unless there are questions, and I will close.
Members, any questions? All right. At this time, House Bill 2291 will be left pending. All right. You sure?
Yeah, but we need to.
Chair now lays out House Bill 4639, recognizes Representative Temach to explain the bill.
Thank you, Chairman Guillen, Vice Chair Johnson, and the committee. I appreciate the opportunity to lay out House Bill 4639. The idea of
Representative Troxclair offers up committee substitute. Chair recognizes Representative Temach to explain the measure.
Thank you so much. The idea for this bill was brought to me by a constituent who is a law enforcement officer in my district. The officer realized that if he pulled over a vehicle with multiple occupants and the passenger was in possession of a firearm while also committing another crime, or was someone who is prohibited by law from possessing a firearm, the statute is unclear on whether or not the passenger of the vehicle could be arrested for the offense of unlawful carry of a weapon. Section 46.02A1 of the Penal Code states a person commits the offense of unlawful carry of a weapon if the person intentionally, knowingly, or recklessly carries on or about his or her person a handgun in a motor vehicle or watercraft that is owned by the person or it is under the person's control at any time in which the handgun is in plain view unless the person is 21 years of age or older, or is licensed to carry a handgun and the handgun is carried in a holster, or the person is engaged in criminal activity other than a Class C misdemeanor that is a violation of the law or ordinance regulating traffic or boating, or the person is prohibited by law from possessing a firearm. With the current law's lack of clarity, interpretation of this section has varied from officer to officer and could ultimately lead to an officer not arresting an individual for an unlawful carry of a weapon. If an officer were to arrest someone for unlawfully carrying of a weapon, they could run the risk of the judge dismissing the charge. The committee substitute for House Bill 4639 eliminates language in Section 46.02 of the Penal Code that says a vehicle must be owned by the person or under the person's control. Doing so clarifies that the law enforcement officer can arrest an individual for unlawfully carrying a weapon in a motor vehicle or watercraft if they're also committing another offense other than a Class C and are prohibited by law from possessing a firearm, regardless of whether the motor vehicle or watercraft is owned by the person or under the person's control. After speaking to several law enforcement groups, we've come to learn that this seems to be an unintended consequence of constitutional carry. My intent is not to go back on constitutional carry or to anyone's Second Amendment rights, but to simply close this loophole in statute. Chairman, Vice Chair, thank you again for the time to lay out this bill.
Members, any questions? All right, we'll have you back up.
Thank you for the.
Chair now calls Jake Wilson. We have you registered as Jake Wilson, representing yourself in favor of the bill. Is that correct?
That's correct.
Please proceed.
I'll keep it short because I know we have a long day, but I support Representative Temach's House Bill 4639 and thank her for carrying it, and I ask for your support for this bill.
Members, any questions? Thank you, sir. Chair calls Lori Haas. Lori Haas. We have Lori Haas registered to testify for herself on the bill, but we are switching her to did not testify. Chair now calls Brian Bowen. We have you registered as Brian Bowen, representing the Austin Police Department in favor of the bill. Is that correct?
Yes, sir, it is.
Please proceed.
Hello. Thank you for the time. I'm Detective Brian Bowen with the Austin Police Department. I'm currently assigned to the Organized Crime Division, and I am here to vote in favor of the bill today. I think it helps with just clarifying some of the confusion. When you're about to make an arrest, if the vehicle, the way the old statute states, if you're the owner or the one not in possession of the vehicle, it could cause some confusion as to whether or not you can make the arrest or not if you have an individual who has a gun.
Members, any questions? Thank you, sir. Chair now calls Jason Hester, representing the Texas Department of Public Safety, on the bill as a resource witness. Is that correct? Yes, sir, Mr. Chairman. All right, members, any questions of the resource witness? All right, thank you.
Yes, sir.
Is there anyone else wishing to testify on, for, or against the committee substitute to House Bill 4639? Chair hears none, recognizes Representative Temesh to close.
Thank you. I close.
Members, any questions? All right, the committee substitute to House Bill 4639 is withdrawn, and House Bill 4639 is left pending. As a reminder, members, and audience, we have an overflow room in E2.026 for when we come back after session. Also registration for witnesses wishing to testify or register a position on the bills posted on today's agenda will be closed at noon today. As a reminder, all witnesses should register by that time at the kiosks located in the hallways behind the hearing rooms. The chair moves that the committee will stand in recess until final adjournment or recess of the House or during the reading and referral of bills if permission is granted. Is there objection? Chair hears none. Motion prevails. Committee stands in recess.